The Honorable, the President.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have received the following correspondence from His Excellency the President Anthony Thomas Aquinas Carmona, SCORTT. The Constitution of the Republic of Trinidad and Tobago by His Excellency Anthony Thomas Aquinas Carmona, ORTT SC, President and Commander-in-Chief of the Armed Forces of the Republic of Trinidad and Tobago. To Ms. Ayana Lieber-Lewis. Whereas by the provisions of paragraph E of subsection 2 of section 43 of the Constitution of the Republic of Trinidad and Tobago, the President, in exercise of the power vested in him and acting in accordance with the advice of the Prime Minister, is empowered to declare the seat of a senator to be vacant. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by the said paragraph E of subsection 2 of section 43 of the Constitution of the Republic of Trinidad and Tobago, do hereby declare the seat of you, Ayana Lieber-Lewis, to be vacant, with effect from the 29th of June, 2017. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, this 29th day of June, 2017. The Constitution of the Republic of Trinidad and Tobago. Appointment of a Senator by His Excellency Anthony Thomas Aquinas Carmona, ORTT SC, President and Commander-in-Chief of the Armed Forces of the Republic of Trinidad and Tobago. Ms. Alison West. In exercise of the power vested in me by paragraph A of subsection 2 of section 40 of the Constitution of the Republic of Trinidad and Tobago, I, Anthony Thomas Aquinas Carmona, President as aforesaid, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Alison West, a Senator, with effect from the 29th of June, 2017. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, this 29th day of June, 2017. Honorable Senators, a Senator is required to take the oath.
I, Alison West, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Minister of Labour.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The ministerial response of the Ministry of Finance to the fourth report of the Public Accounts Enterprises Committee, second session 2016-2017, 11th Parliament, on the examination of the audited accounts, balance sheet, and other financial statements of the CPEP Company Limited for the financial years 2009 to 2014. And the ministerial response of the Ministry of Finance to the third report of the Public Administration and Appropriations Committee, second session 2016-2017, 11th Parliament, on an examination of the system of inventory control within the public service.
Minister of Labour and Small Enterprise Development.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in my name. The response of the Registration, Recognition and Certification Board to the third report of the Public Administration and Appropriations Committee, second session 2016 to 2017, 11th Parliament, on an examination of the system of inventory control within the public service. Thank you.
Mr. Vice President.
Madam President, I have the honor to lay on the table the following papers listed on the order paper in my name. The response of the Office of the Parliament to the third report of the Public Administration and Appropriations Committee, second session 2016-2017, 11th Parliament, on an examination of the system of inventory control within the public service.
Reports from committees.
Senator Samuel.
Madam President, I have the honor to present the following reports as listed on the order paper in my name. The eighth report of the Public Accounts Committee for the second session 2016-2017, 11th Parliament, on the examination of the report of the Auditor General on a special audit of the Public Transport Service Corporation, PTSC. 2. The ninth report of the Public Accounts Committee for the second session 2016-2017, 11th Parliament, on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial year 2014 and 2015, with specific reference to the Ministry of Health.
Questions?
Senator Mark.
Thank you, Madam President. To the Honorable Attorney General and Minister of Legal Affairs, in light of the recent reports that a differently abled man had to be physically lifted into the San Fernando Magistrates Court, what measures are being implemented to ensure that all courts are accessible to persons with disabilities?
Madam President, I reached out to the judiciary upon receiving this question as approved. I can confirm that the judiciary has indicated that it intends to continue its exercise of retrofitting all courts in the progress that they're making so far for accessibility issues, both in terms of circulation issues and also technological assistance issues, elevators, ramps, etc. The circulation issues being also something to be factored in the circulation in the environment and in the courts themselves. I can indicate that this has been an exercise which regrettably did not have the force of momentum that it should have had in the period 2010 to date, with only a few courts getting there, the High Court in particular on the order of court itself, but that we intend to pick up that purpose, and in particular at San Fernando, as a special point of focus.
Senator Mark.
Madam President, could the Honorable Attorney General indicate to this Senate which courts in the Republic of TNT have been retrofitted thus far?
Attorney General.
Regrettably, Madam Speaker, Madam President, that would be a very difficult question to commit to the Senate right now. Had the question been posed that way, or perhaps as a regular question, I can certainly get the proper details with respect to all of the many courts. One would appreciate that there are 14 magistrates' courts, 3 out courts, and then there are divisions of the high courts as well. So it would be irresponsible of me to hazard a guess just on the floor of this Parliament in that fashion.
Senator Mark.
The Honourable Attorney General indicate whether there is a program of work scheduled by the judiciary to address this very vexing problem affecting disabled citizens.
Attorney General.
I'm informed by the judiciary that that is in fact the case. I can speak with certainty with respect to the San Fernando Magistrates Court, which has lain in a state of extreme disarray for a very, very long time. Added to that, the intention to treat with the St. Joseph's Convent building, which was acquired in 2010 and which has laid unused now for 7 years, that being the intended site for the family court. So there's actually quite a lot of material. In fact, we've just discovered that a property was purchased in Siparia many years ago for a court as well, which has only just turned up onto the system as being a property in potential development point. So there's quite a bit of work yet to be done.
Next question, Senator Mark.
Thank you, Madam President. To the Honourable Minister of National Security. In light of concerns of a resumption of kidnappings, can the Minister advise whether the Trinidad and Tobago Police Service is properly equipped to prevent and solve such cases of kidnappings?
Minister of National Security.
Thank you, Madam President. Madam President, the Commissioner of Police has informed me that the Anti-Kidnapping Squad, the Cybersecurity Unit, the Task Force, the Criminal Investigation Department, working together with the Strategic Services Agency, is prepared to treat with issues pertaining to kidnapping in Trinidad and Tobago.
Senator Mark.
Yeah, Madam President, could the Honourable Minister indicate to us whether the Commissioner of Police has advised him the status of Mr. Gregory Lane, who was kidnapped at around 3:30 this morning in San Fernando?
Senator,
could you advise us whether
Senator
the
Mark,
police...
I won't allow that question.
Well, may I ask another question?
Yes.
Could the Honourable Minister advise us that the various forces that he has outlined that the Commissioner of Police indicated to him are prepared to deal with any eruption of kidnappings in the country? Could the Honourable Minister indicate to this House whether those units are properly resourced by the state at this time?
Minister of National Security.
Madam President, I thought I just answered the question. Based on the advice of the Commissioner of Police, the unit, as I mentioned before, the Anti-Kidnapping Squad, the Cybersecurity Unit, the CID and the Task Force, and I also added to that the Strategic Services Agency, are prepared to treat with the issues of kidnapping in Trinidad and Tobago.
Public Business, Government Business Committee stage.
Attorney General.
Madam Speaker, Madam President, as I rifle through the procedural paper, may I please be reminded, Madam Speaker, as to whether we actually moved for the committee stage yet? We have not. Thank you. Thank you, Madam Speaker. Madam President, forgive me. Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for matters incidental thereto be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye.
Aye.
Those against say no.
No.
The ayes have it. The Senate will now go into committee of the whole to consider the bill clause by clause.
Madam Chair, may I just, for the sake of order, having come several days after our last sitting, just remind what material we ought to have before us. Apart from the bill, I believe there were circulated amendments, firstly from Senator Ramdeen and secondly from Senator Mark. Are there any further amendments circulated?
And Madam President, we didn't get those amendments either. We were out of the chamber last week, so maybe they were circulated, but not to us who are in the chamber today.
So, Senators Mahabir and Small,
Yeah.
I think everybody else. I'm going to give it to you now.
Very well.
Madam Chair, several members of the government bench, I have mine, but several members of the government bench don't appear to have circulated amendments either.
All right. May I see by a show of hands members, senators who do not have, who don't have the proposed, the amendments which were circulated? May I just see by a show of hands, please? Okay. So, yeah, you'll get it. Yeah. Could
Sorry.
we not? No. Let's just hold on and let everybody get their documents, and then we will begin the discussions. of the amendments, the proposed amendments. Senator Amin, you haven't gotten. Can I just see, is there anyone else? Senator West, Senator Cummings. So okay. Could I just see by a show of hands, please, those who still have not received? So 1, 2, 3, 4, 5 senators. Yeah. So, Julian. Honourable Senators, may I just point out that there are 38 clauses in the bill and 1 schedule. Okay? You want to say something? Okay. But Senator Mark.
Thank you, Madam Chair. Madam Chair, just wanted to stir the imagination and memory of the Attorney General somewhat. When we were winding up the last rounds in terms of our debate, he did indicate to us that in the other place, several amendments were circulated. And he did accept some, and he did not accept others. And he went on to indicate that those that he did not accept, he was able to circulate in writing a rationale for those that he did not accept.
That's in the other place?
Yes, and he promised in his contribution that he would provide us with that copy of the document that, he had circulated elsewhere. And I don't know if the Honorable Attorney General is in a position to provide us with that document so that in going through the discussion, we could understand his rationale for not accepting, some of these amendments. I don't know if you could probably make it available to us.
I thank Senator Mark for reflecting indeed what was said. Madam President, I have to confess that when we re-looked at the list of 25 amendments proposed by my learned colleague, Mr. Senator Ramdeen, and separating out observations made by Senator Choate from that by Senator Mark, we had in fact traversed the very issues in the House of Representatives, and in fact we had provided the Leader of the Opposition and all members of the House with a gratuitous copy of what our views were on those, as a result of which we then progressed with the committee. I have in fact requested that it be circulated. I wish to apologize that I couldn't do it sooner. I must confess that I didn't finish till very late last night after 11 in the House, and then we've been sitting almost every single day between the two houses in preparing multiple debates. So there is a listing, the vast majority of which we've dealt with in the other place, albeit not here, so it'll be circulated very shortly.
All right. When you say very shortly, can you just tell me?
It ought not to interrupt our progress through the clauses. Remember, Madam President, what I'm offering is something which is gratuitous, as an aid just to allow senators to see positions in advance of where we get. It's not the usual practice that that's done, but I'm very happy to facilitate it because it helps us to better enable ourselves in our considerations.
Chair, the only reason I sought to solicit the support of the Honorable Attorney General is that it would probably save us some time in going through this exercise. But if it is that it will be circulated and there is no time frame, and it's being done, as he said, in a gratuitous manner, well, then we'll have to go through the burden.
Last comment on my part. Madam President, and forgive me, the pause is because I can't remember which house I'm sitting in at times. The position of the government is that we don't propose, we had not proposed to circulate any amendments of our own volition. We certainly have received the views of honourable senators, and we're prepared to distinguish our positions. The large volume of difference, if any, between us is really on a matter of policy, not so much language or otherwise. So I think that we can traverse the regular course, and I think we can get through a fair amount of progress if we were to commence, so that at least we don't hold back the sitting unduly.
All right. Okay. So we will begin.
Clause 1.
The question is that Clause 1 stand part of the bill. Senator Ramdeen, you have proposed amendments to Clause 1. Would you like to just indicate your reasoning, your
Honorable
rationale?
Attorney General, I think that by now we've become accustomed to having the proclamation clauses there, because one understands that there is a certain degree of operationalization that needs to be done before these bills can be put into effect. But the concern that we have is that there have been a number of pieces of legislation that have been passed with proclamation clauses and are yet to be proclaimed. And I think that the time is coming close to where we are passing a lot of legislation, but the time period for the proclamation is becoming quite lengthy, if I can put it in those terms. So I was wondering whether we could put a date so that we would understand that these very important pieces of legislation will come into effect at that time. Obviously, it will be based upon your knowledge of how far you've reached in terms of putting into effect what the foundation for what needs to be done in order to get this in there. So that the purpose for doing that is simply to be able to tie us down as a not to tie down the government, but basically to set an outside time frame for us to be able to know that what the laws that we are passing is going to have some effect, because they're going to be brought into effect on or before a particular date.
Attorney General.
Yes, I thank the Honourable Senator for raising a very real issue. The fact that successive governments have fallen into difficulties in proclaiming laws as opposed to just passing them. By my estimation, I think we have one particular piece of law which we've passed, which is yet to be proclaimed. That's following upon the instructions of the Cabinet arising only just today. Whilst I do appreciate the anxiety which we should move ourselves with and the anxious scrutiny we should have to dates, the government's not in a position to include a date for proclamation. We prefer to stay with the standard formula that the Cabinet take that decision, lest we find ourselves in difficulties in the laws as expressed. So most respectfully, we don't propose that we amend the clause as suggested.
All right, so honourable senators, the question is that Clause 1 be amended as circulated. Those in favour say aye. Aye. Those in favour say...
As circulated, sorry, no. So we will it's a good thing I have no voice in this house.
Those in favour say aye.
Aye.
Those against say no.
No.
The noes have it. I will now put the question on the original Clause 1. So the question is that Clause 1 now stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 1 now stands part of the bill.
Clause 2.
Okay. So Senators Mark and Ramdeen, you have proposed amendment. So the question is that Clause 2 stand part of the bill. Senator Mark.
Yes, thank you, Madam Chair. Madam Chair, we are very concerned, gravely concerned over this term or word that has been added to the legislation in several parts of the legislation, but we are dealing specifically with Clause 2. And again, we have in our jurisprudence, the practice has always been, and I think it has been made very clear, that the judges' rules and directions to police in this country is that if you hold someone, you better charge that person or caution that person and have that person released. But it is unusual, and we are in 2017, and we live in a democratic state, and we have a very corrupt element within the police service, which sometimes do the political bidding of parties. And therefore, we have to be very cautious that we put into our legislation this concept, Madam Chair, of a suspect. So the police can arrest or can bring somebody in, Madam President, and in the absence of whistleblowing legislation, this can be used as a political weapon.
Okay, so
what I'm arguing is that in our modern jurisprudence, there is no room or place for this particular position that the government is insisting is a policy position. And apparently, Madam Chair, he's saying it is not negotiable because it is a policy position. And we want to make it very clear, Madam Chair, that we cannot support a concept, a term, a word in this context in the way that is being proposed. There are many dangers associated with that. And Madam President, we are not in Nigeria.
okay, Senator Mark, I think you've proposed your amendment.
So I want to make it very clear that we will not support the inclusion of this concept, this term, this word in our legislation.
Yes.
And we are calling on the government to delete it wherever it may appear.
Senator Mahavier.
Okay. Thank you very much, Madam Chair. Madam Chair, I understand Senator Mark's concern, but this is addressed to the Honorable AG through you, because what it says is that suspect means a person whom a police officer with reasonable cause, and I need, for my own clarity, to know whether with reasonable cause has an established definition in court processes, or whether reasonable cause simply is an arbitrary phenomenon.
Attorney General.
Thank you, Madam Chairman. Firstly, in response to Senator Mark, the government proposes to maintain the application of plea bargaining through the judicial process which we have constructed. That is through a plea discussion and a plea hearing before a court of law, in respect of which there is a right of appeal, and in respect of which there are procedures for certification of positions, including the videotaping of evidence, the certification in writing by both represented and unrepresented persons, in both categories, suspect and accused. We propose to maintain to that position because, firstly, it is something which is found in the existing law as it is applied in practice in the office of the DPP. Secondly, insofar as it forms part of the laws of many of the Commonwealth jurisdictions to which we have looked for guidance. And thirdly, insofar as we feel that there is proportionality in the management of this position. So we beg to differ with the approach. We do accept that there is no perfect system. Some of the observations raised by Senator Mark are indeed perhaps quite real at times. I don't seek to distance myself from the concern, but I think that we've provided for it adequately. With respect to the inquiry on the part of Senator Mahabir, I can say that the rationale for including the definition as it is here, that a suspect is tied to a policeman's view which is reasonable, that's something which has been the feature of much interpretation over the years in the judicial process. And the reasonable cause, the reasonable understanding is something which, if is unreasonable, can be treated with by way of a claim against the police. I must remind that there is also caveat in this legislation for the use of what we call an improper inducement, where the court must be satisfied that there is no improper inducement. And that's a fairly broad categorization as well. Where policemen find themselves out in the cold, usually finds footing in malicious prosecution or false imprisonment claims, frequently brought against the state in the person of the Attorney General as the defendant. So there is ample judicial understanding of this term, and we prefer to leave it open so that the courts have flexibility to develop themselves as the common law often does.
Madam President, if I can.
Senator Richards.
Thank you. Through you, Madam President, in furtherance to Senator Mark and Senator Mahabir's concerns, because I'm not a legally trained mind, if the AG could just differentiate between what in some jurisdictions is used as a person of interest as opposed to suspect, and if they can be used interchangeably in terms of legal understanding in this case.
Okay, and Senator Choate, you have a question as well?
I do, but it's a general question because I had, in my presentation, I'd made several suggestions. Some were stylistic, but some were substantial. So I just wanted to propose those amendments.
To the term suspect?
No, not to the term
right,
suspect, but simply with respect to clause 2.
Yes. Okay, so let's just deal with, I'm trying to just deal with the amendment as circulated by Senator Mark, which is specific, and then we'll come back. Attorney General, Senator Ramdeen.
Attorney General, I was wondering, because I've now been past the responses, and in relation to, I understand your policy position. I understand that on the last occasion you told us the government is not prepared to move on the policy positions. Now, I just want to say that while we understand the policy positions and what the policy positions are based upon, I think it's important for us to have an open mind in the committee stage.
And we do.
Yeah, I'm just saying, because at the end of the day, while it is appropriate for us to get as much assistance as we can from third parties, the responsibility for what goes into the bill rests with us as a parliament.
Sure.
And therefore, whatever may be the policy positions that may have been advanced by stakeholders in consultations and what advice you would have gotten in your position as Attorney General or the government prior to you, I think it's important for us to objectively look at those positions and see whether as a parliament is in the best interest while we're passing it. So I just hope that we can have an open mind about it so that at the end of the day, whatever we do in relation to suspect, it can be things. What I wanted to ask is that when Senator Sturge made his contribution, I thought that it was very useful, or perhaps more than useful, properly grounded in relation to the judge's rules, as to the way in which the judge's rules treats with someone who is a suspect or who is someone that the police has reasonable cause to believe has committed a crime. And the way in which the judge's rules has laid down the manner in which police treat with someone who they have reasonable cause to believe has committed a criminal offense. I was wondering if in your deliberations as Attorney General, in bringing the legislation, whether that was actually considered at all in relation to making suspect a part of this law, and whether the consequences of the judge's rules have been considered.
Yes. I'm very grateful, Senator Ramdeen, for the reminder of Senator Sturge's point. We, in fact, raised this issue with the drafter of the bill, Mrs. Elder, who really, coming out of the observations in the House of Representatives, preferred to amplify the treatment of suspect away from just the definition of what an accused person was. Because if you recall, the bill in the House really started off with a definition of an accused person which included a suspect. And then the treatment in the bill didn't disaggregate the two into the limbs as we have now in the bill that is before the Senate as amended in the House. Our inquiries of our own, our consultation, etc., certainly did include reflections upon the judge's rules, and all of the feedback that we've gotten so far in relation to it is that we would not be colliding with those rules. Again, for the reasons that I've expressed in the opening salvo on the expression. I'd just like to add, Senator Ramdeen, the government's mind is entirely open, because policy doesn't necessarily mean prescription. But one can prescribe policy in a number of different ways. So our minds are certainly well open to entertaining the Honourable Senate and all contributions made in respect of any improvements on this bill.
Attorney General, have you addressed Senator Richards?
Sorry, you invited me to respond to Senator Ramdeen, please.
I'm trying to close off the...
Yes, ma'am, I can now.
Yeah.
With respect to the inquiry as to person of interest versus suspect, we prefer to stay with the term as is used in the local arena. The Criminal Law Act would also have had in Section 3 treatment of this terminology, so we tried to keep it in tandem with the statute and common law practice in the sense of the terminology used. Senator Choate had raised a number of concerns.
We're
You
not
were
going
there
to deal
yet?
with that. We're dealing specifically with the
That circulated.
proposed amendment as circulated by Senator Mark. Senator Solomon?
Yes. Thank you. Honorable Attorney General, my concerns with suspect is founded in that period of time where a person is first arrested by the police and not yet charged. And that time period is always a very vulnerable time period, in particular for the suspect, and open to a lot of intimidation and malevolence by police officers to put pressure on these persons and give them the impression that they may have to, as I would say, make up stories to get themselves out of an immediate situation. And I would submit that the judge's rules are wholly inadequate for a lot of these initial arrests and interrogations and detentions, and also needs a lot of tightening up. And that is the danger with this, is that you're empowering a situation of vulnerability where police officers who may be open to abuse, malevolence, maliciousness, political influence, inducements, where they can give the person the impression that their life is about to end, their liberty is about to end, if they do not either make up stories or give evidence or...
Okay, Senator Solomon, I think
that
the point has been made.
Madam Chair, I just want to close to say that it's extremely important that if you're doing this sort of stuff, in the United Kingdom, they had PACE 1984, the Police and Criminal Evidence Act, and that governs the detention. And this needs to be, particular attention needs to be put in relation to the judge's rules and this piece of legislation. I would urge the Attorney General to reconsider this.
Attorney General.
May I ask a bold, square question? Is the thought process behind the statement just made, Senator Solomon, that the government should consider removing the inclusion of a suspect from this?
Changing the definition or removing it, yes.
So in removing the definition of suspect, the proposal on the part of the opposition is treat only with persons who have been charged and who are accused and do not consider suspects. Is that it?
I would say yes. Yeah.
If that's the case, then most respectfully, we are not prepared to agree to that position for the number of reasons, most important of which lies in the architecture of the bill itself, which provides for judicial scrutiny. Clause 4 in particular of the bill, which treats with what an agreement actually is, how discussions happen, and then the entire judicial supervision, including improper inducements, cause us to form the view that we think that we're on safe ground with respect to the inclusion of suspects.
Honourable Senators, the question is that Clause 2 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no.
No. What is the vision on that?
Mrs. Batiste Primus?
Yes?
No.
No, Madam President. I was temporarily distracted.
Yes,
Mr.
I'm
Rambra.
present. No, I disagree.
Mr. Rambra? Mr. Sinanan? Mr. Moses?
No.
Mr. Hussein? Ms. West?
No.
Dr. Henry?
No.
Mr. Singh?
No.
Mr. Coppin?
No.
Mr. Cummings? No. Mr. De Freitas?
No.
Ms. Bash?
No.
Mr. Duki? Mr. Mohammed?
No.
Mr. Mark?
Yes.
Mr. Solomon?
Yes.
Ms. Amin?
Yes.
Mr. Samuel? Mr. Ramdeen?
Yes.
Dr. Mahabir?
Abstain.
Mr. Small?
No.
Mr. Srikisun?
Abstain.
Ms. Ramkisun?
No.
Ms. Chotasi?
Abstain.
Mr. Kreese?
Abstain.
Ms. Raful?
Abstain.
Mr. Richards?
No.
Dr. I know. Yeah, so 16, 5. 4. In agreement, 16, 5 excellent.
Honorable Senators, in respect of the amendment as proposed by Senator Mark, 4 senators agreed with the amendment, 16 voted against it, and there were 5 abstentions. So the amendment is not allowed. We continue now with the amendments proposed to Clause 2 by Senator Ramdeen. Senator Ramdeen, yes.
I wanted to go to the definition of improper inducements.
No,
No.
Senator Ramdeen, let's go according to how you filed it. So your first amendment, proposed amendment, is to deal with offense.
Yeah, AG, my simple explanation for it is I don't think that is necessary. I think it's otious. The offense can only be a criminal offense.
Sure.
So I don't think that there's any need for us to
Well,
do that.
thank you. If I could just put it on the record, the rationale for, yes, it's supposed to be criminal offense, but when we went to the Interpretation Act and we looked to what the meaning of an offense was, it included administrative fines. So to exclude that aspect of it, we erred on the narrow definition of a specific statement that it's a criminal offense. And that's the reason why we put it in.
Okay. All right, and Senator Ramdeen, with respect to plea agreement, your proposed amendment?
That too, AG, I think it's self-explanatory from the proposed amendment.
We ran into recent litigation concerning the inclusion of broad definitions substantively intended to articulate, included in the text of definition clauses like this, for instance, in the Anti-Terrorism Act. And the prevailing view coming out of it is that we ought to carve it out and put it as we have with the definition in Clause 4. So Clause 4 is where we have a full definition in the body of the law for plea agreement, and that's why we've preferred to stay that way. That's the advice coming also from the CPC's department, relative in particular to Helen Zantaki's book, Drafting Legislation, Art and Technology of Rules and Regulations, and what they call Thornton's 10 Commandments of Drafting, that you ought to carve this away from a broad definition usage in a clause such as this, an omnibus clause definition, and instead leave it as a standalone.
But is it necessary? Having regard to the fact that under Section 4, you already have a specific definition of what a plea agreement is. The fact that you come, is it serving any purpose in having it as a plea agreement? That's basically the issue. Is it serving any purpose of saying that a plea agreement means an agreement made between the prosecutor and the accused person or suspect under Section 4, when under Section 4, you define specifically as to what a plea agreement is, and there can be no issue with respect to that.
Sure. That's again coming out of the current standard as to how we draft, because where a term is used, plea agreement, throughout the bill, plea discussion or plea agreement, the cross-reference to the clause is usually required just out of an abundance of caution for drafting. What I was looking at in my response was in the draft as circulated, the proposals on your part, that the definition be modified because it was suggested that the plea agreement there was a deletion and then an improvement of words. So it was in respect of that I was responding.
But you're prepared to leave it as is?
Yes, please.
With respect to Prosecutor AJ, I know you've said this is because of the advice and the policy position that has been taken. I understand, well, having read the material, this came out of Mrs. Elder's contribution with respect to the fact that we should not include police officers. I was wondering, in terms of whether we have the resources to implement this kind of legislation, having regard to the statements that you made. I think it's 95% in terms of the statistics that prosecutions are done by the police officers. And what is the difficulties that will be encountered where you have how many magistrates' courts in the different parts of the country, and the first responders, if we could use that word, in relation to suspects and accused are going to be the police officers. It very rarely at the magistrate court are you going to have state counsel unless the state counsel has been assigned for a particular matter or the seriousness of the matter requires state counsel there. And whether the DPP's office is going to be in a position to implement this type of legislation with the far-reaching tentacles of the definitions as to suspect and accused persons, and whether there's going to be enough of a relationship between the TTPS and the Office of the Director of Public Prosecution to make what we pass here effective so that there could be some results out of it. That is the concern.
It's a very wise observation. Certainly it touches on the pulse of the true functionality of everything, be it abolition of preliminary inquiries with DPP stepping in or the utilization of plea agreements as we propose. I should say that we are not only agitating the build-out of the DPP's office in terms of the numbers, because the next stage for a further 32 to 40 lawyers is due to kick in September. But we're also providing, we're just awaiting the DPP's A, nomination of a further 40 lawyers, if I remember the number correctly, B, his confirmation of new Port of Spain offices, San Fernando offices, and Tobago offices, all of which have been selected by him for moving. But more importantly, in the work that we're doing to improve the prosecutorial arm, one of the proposals for management of prosecution on the part of the state is to have a seconding of TTPS attorneys across to the office of the DPP to further improve the relationship between the prosecutorial arm of the police and the inspection by the DPP's office. I must add that in particular there's a natural association between the TTPS and the DPP's office, and some of this road can be made a little bit easier to walk once the DPP actually appoints his deputies and allows the positions to fold in terms of that. So that this is one of the reasons why we put in that proclamation clause. These are very anxious discussions that we're having with the DPP's office with a proposal to try and make this thing come alive through the provision of resources and coordinated working relationships between the TTPS and the DPP's office.
Can I ask whether it has been considered that if we don't go all the way of making a TTPS officer over of the first division someone who could conduct or fit into the shoes of a prosecutor in a sense under the Act, whether we can't facilitate a hybrid position of having a TTPS officer above the rank subject to the approval of the Director of Public Prosecution?
It's an interesting thought, again driven by a resource consideration. The difficulty that we had in terms of a policy balance was that there was such fierce opposition when it came to the improper inducement argument that the TTPS was quote unquote, and this is the arguments coming forward, I don't say it now as in the position that I hold, but there was such fierce opposition and allegation against the TTPS being involved, particularly on the improper inducement end. And for that reason, the recommendation coming out of the 2014 workshops and move its way forward was that there be a complete move away from the TTPS. And this, in fact, was endorsed by the DPP himself in the period 2014 come forward. So there were multiple stakeholder submissions on that basis, which the government's policy chose to solidify.
That's why I was just wondering, the halfway position of not giving them the authority to do it.
May I put it this way? Insofar as we are experimenting, if I could use it that way, with a solution which has not really been utilized, the 1999 come forward position, it may very well be that if the resource allocation demonstrates that we ought to amend the definition at a subsequent date, it would still be open. In the period whilst we build out the capacity in the next couple of months, as the case management centers come alive in the different parts of Trinidad and Tobago, that's where we're really going to know what the resource position looks like. Because we've also asked the TTPS to hire up its attorneys as well. There is an open capacity for attorneys to take position in the TTPS that has not been filled, notwithstanding the availability of the budget for it and the positions being open and existing.
Senator Mahabir.
Yeah, thank you very much, Madam Chair. Madam Chair, Clause 3 of this Act says this Act applies to both summary and indictable offences. And I want to link this with the suggestion of Senator Ramdeen. I have total sympathy with the point raised by Senator Ramdeen with respect to the fact that this particular bill, the objective, Honourable Attorney General, is to really expedite justice. You want to make sure that there is a very swift process by which we can bring justice to the people of Trinidad. And I'm simply wondering, what is the problem from your perspective with simply appending to Senator Ramdeen's his suggestion, the rank of the officer of the First Division of the Trinidad and Tobago Police approved by the Director of Police, the Director of Public Prosecutions? You see, my view is that once that particular officer is approved and has been subject to the scrutiny of the DPP, then that officer in place in the summary courts will in fact achieve the objectives that you want to achieve. So I want clarity again from you as to what is the mischief by having one of these police prosecutors approved by the DPP in the current bill as we are debating.
Attorney General.
It ties into our move to remove the offence which exists in Section 5 of the existing Act for an improper inducement. Under the existing law, one of the strong points of opposition was that the criminalization of an improper inducement, the provision of an offence, a term of imprisonment, and a fine, dissuaded prosecutors, as defined, including police officers, from utilizing the process. The second limb of strong opposition and mischief was that there were police officers involved per se. The mere fact that they were involved fell into odium. And from that perspective, the recommendations coming out of the umpteen policy discussions and workshops, etc., including from the international fulminations, which one could argue are divorced from the realities of our resources, because we're talking now about resource allocation. I accept that that's a bona fide point. But from a policy perspective, the request was to remove police prosecutors entirely, of whatever rank, because the allegation is that they all fit into the same barrel. From that perspective, we propose specifically in the National Prosecution Agency that we're building out right now to actually have a degree of overlay, DPP's office overlaying the prosecutorial arm of the TTPS, where they stand together. So that may be something which we look at a subsequent point. It's not uncommon to come, as we have, and you will see in September, to layer and fix certain things, as we will in the Children and Family Division Court or the Children's Act, as we've spotted the other day in Section 59 of the Children's Act. We're going to have to come back at a second pass at a couple of these things. But for now, we would need to have a bit more consultation on that concept, and we've got to err on the side of the policy as approved by the Cabinet.
All right, so Honourable Senators, the question is that Clause 2 be amended as circulated by Senator Ramdeen. Those in favour say aye. Aye. Those against say no.
No.
So the amendments are not accepted. Senator Choate, you wanted to raise some issues with Clause 2?
Yes, Madam Chairman, thank you very much. I had suggested some stylistic changes in terms of 2B, to say indictment is preferred and includes a defendant, and court meaning a summary court. But the substance of my suggestion or proposal was in relation to improper inducement, subsection C, where I am proposing that after the word suspect, we insert the words by any person. So it would read the coercion of an accused person or suspect by any person. With respect to C1, I am respectfully proposing that after the word charge, we insert the words or cause a charge to be laid. So it would be, C1 would be to lay a charge or cause a charge to be laid of the type described in paragraph A or B or and so on. With respect to subsection D,
Could I ask that we take them one by one, if that's possible?
Well, are the amendments interrelated that you're proposing, or can we deal with what you have proposed for C? Now, Senator Chu.
Certainly, we can do it that way.
All right. I actually would have preferred that we go through what Senator Choate is proposing, and then we'll deal with it. It makes, to me, it'll flow a little easier. So, Senator Choate, just continue.
Madam Chair, if I could explain why, because it's not in writing.
No, I'm writing it. So let's just hear Senator Choate out, and then we'll decide. Let me just hear what is the proposed amendments, okay? Senator Choate.
With respect to subsection D, I am proposing that after the word prosecutor, we insert the words or anyone acting on his behalf or anyone involved in the investigation of the matter. So D would read, the misrepresentation of a material fact by the prosecutor or anyone acting on his behalf or anyone involved in the investigation of the matter, either before a plea discussion is entered into or during the course of the discussion. With respect to E, I am respectfully proposing after the word not that we insert the words capable of being fulfilled. So it would read, E would read, an offer or promise, the fulfillment of which is not capable of being fulfilled by the Office of the Director of Public Prosecution. So, in addition, we remove the words, the function of. And with respect, if I may go on to page 4.
Okay, so, all right, let's stop there, and let us deal with the amendments proposed by Senator Choate to clause 2 on page 3 of the bill. Attorney General?
You'd have to assist me, Madam Chair.
Not a problem.
Yeah.
So, the first amendment, Senator Choate, you will let me know if I'm going correctly, is subparagraph C, the coercion of an accused person or suspect by anyone to enter into a plea discussion, including a threat. So you're including the words by you have any person, by any person. Those are the words that are being included after the word suspect. The coercion of an accused person or suspect by any person.
Got it.
And you were saying something else there?
No?
Oh,
I continued.
by any person.
Yeah. Attorney General?
Yes, Madam Chair. Okay, so with respect to the proposal for an improvement under the definition of improper inducement at subparagraph C, I see it here. So include after suspect by any one or any persons, the coercion of an accused person or suspect by any person to enter into.
Yes.
Madam Chair, in reflecting upon this coming out of the debate, I had a chance to speak with the CPC's department, and the advice coming out of the CPC's department was that the words were actually inclusive, that there was no need for an express utilization by any person, as it's understood in the interpretation of legislation that it applies to all persons unless prescribed otherwise, so that there's a general aspect. I do catch the mischief that Senator Choate is raising. I recall from the debate the reflection that you may have a senior officer giving instructions to a junior officer who just performs a function, and therefore the senior officer may be the person who has the culpability for giving the instructions. But I think that that is safely balanced by Clause 7 of the bill, which allows for a wide utilization of improper inducement, where there's a general prohibition, in respect of which a number of remedies are available, albeit on the common law side, to discourage that position. So the advice coming from the CPC's department in summary is, one, that the words are to be construed as expansive in an interpretation sense. Two, they would only be narrowly construed in the event that you put words to limit those aspects. Three, that the contradiction against improper inducement is one when you look to Clause 7, is one which is expressly frowned upon, albeit not to the sense of what Section 5 had, which was a criminalization of it, but to the extent that there are common law remedies for somebody who acted in that way once the court has made those observations. So in those circumstances, the proposal is to not include the words by any person. That was C1. I did... That's C.
And then 1 will be to lay a charge and insert the words after charge or cause a charge to be laid.
Okay. The position in respect of that is that police officers are no longer involved in the plea discussion. A plea discussion actually happens when the DPP gives written and express consent for a plea discussion, and the DPP's office is involved there. The definition of an improper inducement, again, includes any coercion of an accused person or suspect, and it in fact includes a threat to do things. So when we look to the definition, the cohorts around the crime, those matters for which you can actually find grounding even in the Interpretation Act, where a threat or a conspiracy to take you there can actually be implied, and I'm using very broad senses here. The CPC's department, in discussions after the contribution that we heard from Senator Choate, gave the view that, again, the balancing act was that the threats were in fact included. If you cause a charge to be laid, what I understood behind that mischief was, again, the senior officer speaking to the junior officer. But this must be something which the accused, in fact, is presented at the plea hearing stage. So all discussions, and particularly where the judge begins to traverse the accused or suspect who's now charged, those matters have to come to the satisfaction of the court that there was no improper inducement present. So I don't respectfully think that it needs to be amended. I'm open to persuasion otherwise. If I've got it wrong, Senator Choate.
Well, with all due respect, Honorable Attorney General, I think that you have.
Sure.
C1 talks about laying a charge. Laying a charge in criminal procedure is to do a particular thing, either orally make a complaint before a court or to file a document setting out what the offense is that the person is charged for. Now, I don't think that you have addressed the issue or the defect in this aspect of the proposed legislation, because it may be someone who is unrelated to the I suppose, the discussions between the prosecutor and the suspect or accused person, but it may be someone who, before those discussions were engaged, had used the opportunity to coerce the person by suggesting that they should enter into such discussions and suggesting that a charge may be laid as a result of that.
Sure.
So I don't think it's sufficient to say that that person has a remedy if things go wrong. Why not say that it's wrong in the first place?
But respectfully, C reads with the chapeau adding into subclause 1, Roman 1, the coercion of an accused person or suspect to enter into a plea discussion, including a threat to lay a charge of the type described in paragraph A or B. That's a threat by anyone. It's not limited to Officer X necessarily. I see Senator Ramney doesn't necessarily agree. But the way I read it from an expansive view of it was that it really did include anyone who caused you to do that, because it's the coercion on the suspect. If we look at, for instance, the issues which have come up in the anti-gang cases, where people have come to the court and brought claim, and they are met with a defense, and then they inquire of the officer who laid a charge, well, what's your reasonable belief to have laid the charge? And it may or may not have been the case that, well, Officer X told me, my superior told me to lay the charge. That's good enough. Do we need to respectfully deal with the person who caused the charge to be laid? The fact is that it is the coercion of an accused person to enter into a plea discussion, including a threat which he may have received to lay a charge of the type described in A or B. It's whatever is offered to him. It's not necessarily driven by who offered it. Who gave the threat is irrelevant to the fact that he was coerced.
Honorable Attorney General, with all due respect, I don't see that your response is addressing the concern which I have. If we may take it from the top.
Sure.
Improper inducement talks about, first of all, the laying of a charge not believed to be supported by provable facts, right?
Yep.
B, the laying of a charge that is not usually laid with respect to an act or omission of the type attributed to the accused suspect or person or suspect.
Yeah.
And C talks about something different, the coercion of an accused person or suspect. And you don't agree with my initial suggestion, so I will continue reading. To enter into a plea discussion, including a threat, to lay a charge or cause a charge to be laid. We are now talking about persons who may have contact with a suspect before the laying of the charge and before the plea discussions have begun. In fact, it may be the coercion by these persons which may lead the plea discussions to begin in the first place.
Sure.
So it is for the protection of the suspect who is in custody that I am respectfully proposing that the words "or cause a charge to be laid" be inserted.
Senator Choate, I'm concentrating on the word threat, because it isn't that a charge has to be laid. There can be a threat of a charge being laid or caused to be laid. I understand what you're saying, Senator Choate. You're saying that the suspect comes in the door, meets Mr. A. Mr. A gives him some coercion. He then comes into contact with Mr. B, and Mr. B is now doing the event, but his mind may be operating on the interaction with Mr. A. I understand that. So the question is, in the submission that you've put, you're saying an improper inducement includes the coercion of an accused person or suspect to enter into a plea discussion, including a threat to lay a charge or cause a charge to be laid. but or cause a charge to be laid is in reference to the Mr. A who instructed Mr. B, or that the mind of the accused or suspect was operating on the fact that somebody else would come and lay a charge. But I don't see that we advance the position by or cause a charge to be laid. I just don't see it.
Well, Honorable Attorney General, I don't think that I can explain it more plainly, so I thank you for considering my proposal.
Okay, so let's just deal with the proposals.
I think Senator Ramleen had a view as well on this.
I see the, I think that I understand the mischief that, that Senator Choate has advanced in terms of putting in some type of definition of who is supposed to be doing this inducing, because while perhaps I might not borrow the same words by any person, I think that it makes, respectfully, a nonsense of all of these provisions if we don't define who is going to be doing the inducing. Because one can, if you have anyone, like you've explained, doing the inducement, one can see that if you, perhaps we're looking too much on the prejudicial side of what can happen to an accused person. But if you look at it from the other side, which is if an accused person wants to set aside a plea agreement, look at it from the other side. It could be anybody in anybody who has no authority to do anything, because you test these definitions by taking them to the extreme. If somebody who is totally unconnected with a prosecution tells someone, if you do this, this will happen.
Or if you don't.
Or if you don't, then it can't be that it is an open-ended position that I, as an accused person, could walk into a police station, John Brown tells me, do this and this will happen. And that can be used as an improper inducement. It just doesn't make any sense. Legislatively, I mean, not with any disrespect at all. Yeah. It just does. We must be able to say who is doing these things, all of these misrepresentations, promise, offer, all of these things. They must be circumscribed in some way.
Madam Chair, may I, with the intervention of Senator Ramleen, ask of Senator Choate, because I'm trying to understand not only the mischief but the remedy to the particular mischief. What I understood from Senator Ramleen's reflection upon our discussion was that if we flipped it on the other side and we're looking to who caused the improper inducement, that the inclusion of the words or cause a charge to be laid would be to limit the class of persons who may have been involved in the improper inducement, not just anyone. Legislatively, I quite preferred leaving it as wide as possible to be tested, because I couldn't contemplate all the circumstances of an improper inducement now. So the rationale standing behind the submission that I've made is in fact to encourage a very open door, that it is in fact anyone, because it is for the court to step into the objectivity or pseudo-objectivity of the accused person who makes the allegation that I am the victim of an improper inducement because John Brown said if I didn't do this, this would happen, or if I did this, this would happen. Because the law being read as a whole, from a legislative interpretation perspective, the law must be read as a whole, and then the specific sections going there. When we look to not only the definition of improper inducement, but we go to clause 7, and we look to what the judge considers in the plea discussion and what the judge considers about the plea discussion at the plea agreement stage, it is for the judge to come to the view that there wasn't an improper inducement in the very broadest sense, where the accused comes before the court, and at that point, and even on the appeal, because the bill provides for an appeal where you've entered into a plea agreement that you don't agree with, or you want to set it aside, where they come and say in the broadest sense possible, look, I was guilty of I was the victim of an improper inducement. So it is precisely because the view is to keep it as wide as possible to take care of all of the circumstances that we have not sought to treat by narrowing it down. At least this is on the reflection just given.
Honourable Senators, I think there has been enough discussion on these two proposed amendments. So I'm going to put it.
Please.
All right, but please. All right, let me say something before I allow you. Senator Mark. We have had Senator Choate has raised an issue. The Attorney General has answered. Senator Ramdeen has raised an issue on the same matter that Senator Choate has raised. The Attorney General has answered. So it is within my discretion to kind of determine how far the discussions have gone and whether we should put it to the vote. But I will allow you now. But I'm cautioning members that we are trying to allow full discussion, but at some point we'll have to close the discussions and put the issue to a vote. Okay, Senator Mark?
Yeah, Madam Chair, I would like to suggest that on the matters that we are dealing with the leave of the Attorney General, sometimes we would want to reflect on these things because law that we are making and people's lives could be impacted negatively. And therefore, what I'm suggesting is that, is it possible that we can stand down clause 2 and go on to another clause? Because Senator Choate is making some submissions that I want to reflect on. Senator Ramdeen has made some, and also the Attorney General. So these are matters that are weighty and hefty, and we don't want to be, this could be a Section 34, you know.
All right, Senator Mark. Senator Choate has already, we're on page 3, and we have to deal with some other proposed amendments by Senator Choate. Okay, so we haven't really moved on to take the vote as yet, but I'm trying to do this in a systematic way so that all members can follow and we can do it and get through it. So just one sec. So that is the position. Attorney General, Senator Mark was asking whether you want to defer clause 2.
Madam Chair, I wouldn't choose to answer that immediately, and forgive me for not answering your question. I'm wondering in terms of the useful time, if you just permit me a small bit of latitude. The Parliament must end for its compulsory recess next Friday. We have 2 bills yet to do, preliminary inquiries and trial, the bail, the improved access to bail. There are some very important observations, and I don't want honourable senators to think that we're not open-minded in the improvements being suggested, but somehow I get the feeling that more ample discussion may be useful. And I'm wondering, subject only to the availability of honourable senators in the course of next week and their willingness to take a little extra load in terms of a few extra days, whether, I'm laying my cards on the table because we run the risk of having the work of the Parliament in this year come to naught because we stopped specifically to allow the Law Association to give us comments, which they did not under their insistence. But I'm wondering, subject to the availability of honourable senators next week, where we would try to persuade members to come and sit more than twice, whether we could have gone to a special select committee to work out some of these issues, report by Tuesday, and well, we have Friday and Monday that we could easily use. If not, we can continue to go through clause by clause. But you see, this bill came through several iterations, and we have had a lot of consultation, in particular with the opposition in the House. And we're now in a different House, so I can't bring that experience with me to this House. But the observations being made by senators impact upon drafting, interpretation, other different styles. So I'm just throwing it open to you, Madam Chair, with that indulgence. And now to answer your question, yes, we can stand down close to if you wish.
Having heard what the Attorney General has just proposed, and bearing in mind that it is close to 4 o'clock, we have been at this since 2:30, and we are still on clause 2, I'm going to stand down the committee for 15 minutes. I would ask that there be some discussion, and when I come back, we will decide how we are going forward. But I don't think I should be part of the whether we sit in, whether we not sit in, and that sort of thing at this stage. Okay? So I will suspend the committee for 15 minutes and resume.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
Like, if you commit treason against your country by stealing from the treasury, you should be able to be prosecuted and go to jail. Hold the person accountable some sort of way, not just tell them, okay, sign a paper and tell me you resign.
We can't give these people all this power and then not hold anybody accountable. Then, I mean, they're in charge of themselves. You know, when you give anyone too much power, you know what happens, right?
What I believe is that with the responsibility now, it would be that in Parliament, the way they conduct themselves, the views they represent should be those of the people.
Personally, I believe more clarification should be given in the public eyes. Not every citizen will understand the parliamentary language then. They want things at their level.
How do we go beyond just looking at the reports? There needs to be more of a response. Having legislative oversight which reviews audit reports or investigative reports or performance assessments, it needs to go beyond to say, well, did something happen as a result of us looking at that report? So this is the key. Is there follow-up?
A public accounts committee and an auditor general and any other system that you have for oversight can only work if you have the political will and the commitment to transparency.
Transparent promotes accountability because you could have the most perfect system, it could be so well executed, lovely budget, but if nobody knows about it, then nobody's accountable for did it deliver what it was intended to do.
Transparency is crucial. The public demand that. Committees need to be not just open and televised, that committees themselves need to be transparent in terms of the way that they've done business. I like the practice that's taken place in some parliaments where they produce legacy reports at the end of a parliament. The committee should look back and see, well, what have we actually achieved as a committee, and they should report to that. They should report to the people in terms of, we as your representatives, we have done this over the last 4 or 5 years, we've achieved this, these are the issues we've uncovered. This is a problem, a cross-cutting issue that keeps cropping up. And it's not just important in terms of transparency to the public, it's also important for any successor committee that starts up, that they can actually look back so there's greater coordination between different parliaments.
And secondly, it needs to be timely. Quite often we see the reports being less than timely. That reduces accountability. It certainly does not promote good governance and effective management.
We must find a way to involve the average man. And I believe one of the ways to do that is to engage our young people. And maybe in the pre-budget preparation, we throw these things out and have them as young people to debate it. But part of it is, how do we simplify that so the average man can understand? Because you have all these highfalutin terminologies and figures and people can't relate to it. You have to now break it down in simple terms, how it affects their day-to-day lives.
And then, if you want to strengthen parliamentary oversight, one aspect I want to bring, this is political a little bit. The confrontational politics is not serving the interest of the people. So when a party wins the election, it is the responsibility of the winning party how to fold the other oppositions together, work as a team.
Some of the challenges that government has is with the people. So when the people are more involved, then I believe that they can be a part of the solution. I mean, in Jamaica now we're talking about growth. It's not just, when we speak about growth in an economy, it can't be just the big businesses doing well or doing better. It is also about the small businesses. It is where that little man, that little woman see themselves as part of that growth.
First of all, I think it would be important that, of course, when the agenda of the committees are made public and available on the website, that also civil society at regular intervals is invited to contribute. I know that in a number of countries, each committee, they have a roster of civil society experts, stakeholders, relevant persons, which can be called upon to testify in front of the committee on a specific issue, but also to be as a source of expertise.
And so it is, whatever we're doing in terms of public expenditure, saving money, spending more wisely, the people must feel that it is their business, because in fact, it is their money that the government is spending.
I think it's completely unrealistic for people to be intensively following, for all people to be intensively following what is happening and all the time, and in a sense to be governing the country from their kitchens. That's not what's required. What's required is some thought about who they're going to vote for, the quality of their representative, and to take notice when things are beginning to go badly wrong, to be sensitive and objective when they read that something is not right.
Citizens try to see what is the substance of whole deliberations. Unless it is very substantive, they will not be interested. I always advise the Auditor General, it is good that you are submitting thousands of pages audit report to the Parliament, but give me 50 pages. 10 major cases, those should be discussed under camera, and decisions will be taken, and decisions will be implemented immediately, and people will know who are the people penalized for misusing 5 million, 10 million or 5 million. My feeling is that going forward, as Trinidad is one of the leader of the economic development in the Caribbean, I think as a government, both and also the opposition should look at what are the good practices around the world. You look at what you are doing, then you look around what are the good practices. Can you adapt it, learn from them, and develop the society? And that is leadership.
We advise them to go through the standing orders as well as the Constitution of Trinidad and Tobago, right, as their newcoming MPs. I believe that will do them very well.
I would say represent the persons who elected you, because I had the opportunity to vote this year.
The best advice I could give them would be to make sure and learn the rules, the regulations, make sure they know how to scrutinize properly without offending anyone.
Do not just take it for granted and make things into big scandals, and just work for your country. Your country put you there for a reason, so work for them.
When new members come into Parliament, they usually feel overawed and underpowered. For assistance and guidance on the job, they go first to the procedural staff of Parliament, and the relationship between members and the staff is a very close one. The staff run the organisation, and members are always open to discussions with staff. They come to staff for advice. Staff are very open to giving that advice, and that is a big source. But at the same time, they've got their designated party whip, and that party whip will guide them in the way of putting down questions, the best way of getting answers out of the government, and the way to conduct themselves, what a closure motion is, and all the rest of it. So they do have these two.
In terms of new MPs, I think in a way I don't have to give them advice, because most of them, when they come in, instinctively realise that actually select committee work is really interesting. That it's much more interesting quite often than sitting in the main chamber where everybody's just, playing the Punch and Judy sort of politics.
The key thing is to be involved with as many committees as possible, because as a backbencher who's not in the executive but on the legislatory side, it certainly gives you an opportunity to understand governance and how it functions. My advice would be to not only to get involved, but to do a lot of preparation.
They need to firstly learn the rules. They need to learn and understand the standing orders. If they don't understand the standing orders, they should have the confidence to consult with the clerks and to get them explained. Because what you often see is in Parliament is members saying, "Oh, they can't do this," or they can't do that. Well, in actual fact, that they can, they just don't know how to do it. And so it's very important, very much the stage when they're first weeks in Parliament, that they have a proper induction programme. They spend time with the clerks and they go through the rules and expectations of being a parliamentarian. And as part of that process as well, I think they need to be told of the importance of scrutiny, the importance of committee work.
So you get people from all walks of life coming into the legislatures. Teachers, doctors, social workers, people who don't necessarily have expertise in financial scrutiny. Understandably, not everybody in life is an accountant, right? So it's very important to be able to provide some training to members of Parliament and members of legislative assemblies regarding issues like how do you scrutinize the budget? How do you look at a financial statement and understand it? When the budget is introduced in the legislature, how do you ask questions about the budget? When you have the minister or the deputy minister of a particular department there, what documents should you be using to get ready for that hearing? All those kinds of questions are very, very important. Similarly, after the budget has been expended and you've got the Auditor General's report that's come out, right? And you've got the deputy minister of a particular department. What kind of questions should you be asking the deputy minister? How do you hold the government to account?
My advice to anybody coming in is try and keep the politics out of it. Try and keep it issue-based, and actually you'll enjoy it more as a member, but you'll be way more effective in terms of the service that you provide to your citizens and actually to government, because sometimes governments do need to be told what isn't working, even if they don't want to hear it.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
I don't think you can separate Parliament from everything else that's happening in societies.
If you have taken ownership of your country, just like your home or your own business, you're going to be interested in how it is run.
You also need citizens, members of the public, who are really engaged with the political process.
How the monies are being spent, where can we save, and your role in all of this.
A lot of it is sort of a bit dull and it's a bit boring, and there's also a lot of politicians who are fighting and calling each other names, and a lot of the time that means citizens just go, do you know what, I don't want anything to do with that.
It's more a psychological shift as a people, I believe, in taking ownership of country.
But at the end of the day, wherever you live, the quality of your hospitals or your schools or your roads, everything is determined by these politicians.
Governments don't spend government money, they spend people's money. It's taxation money, and it's important that the government be open and accountable for every dollar they spend.
So if we want accountability,
I suggest that we probably give them another 10 minutes because they're still in discussion in the agenda.
I understand that a little more time is needed, so I will return at 4:30. All right, so we are suspended until 4:30.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
A parliamentary icon, the life and chronicles of Cletus Arnold Thomasos. The life of Cletus Arnold Thomasos began on July 23, 1906. He was born to Saran and Eudora Thomasos in Arima, the sleepy little town that would be his home for most of his life. His father, Saran, was a poet who spent most of his life traveling away from Trinidad and Tobago shores. As a result, Arnold Thomasos was raised by his grandmother, Ma Sabe, whom he adored with all his heart. She was to be a strong influence in his life, teaching him the values that would guide him throughout his life. His early career, however, did not immediately take him into the political arena. His first foray into the working world was at the tender age of 14, where, straight from the Arima Roman Catholic Primary School, he went off to work as a clerk in Miller's store near the Arima Dial. However, his desire to further his studies was unwavering, and he returned to the pupil-teacher system, where he found his true calling as an educator. He would then go on to dedicate the next 35 years of his life to the teaching vocation. In the heyday of his educational career, he was widely known as Teacher Arnold, having taught at Arima Boys Roman Catholic School, then moving to head teacher postings at the La Pastora, San Rafael, and Boissier Village RC schools. Many of the pupils he taught were influenced by him and still talk about him with respect to this day. It was at school he also met the love of his life, where at the age of 24 he married Theodora Inez Austin, who was also a teacher, and together they had 5 girls: Joyce, Cynthia, Gloria, Jeanette, and Patsy. Surrounded by his loving family, he continued the tradition of taking care of the younger ones, adopting 2 granddaughters, and like his beloved grandmother, brought them up as his own. But teaching wasn't all Arnold Thomasos did. In his younger years, he was an avid cricketer and also wrote poems and short stories. His love for books led him to join a literary group in 1946, whose members included luminaries such as Errol Hill, Ernest Carr, Barnabas Ramon Fortune, Neville Giuseppe, Edgar Mithelholzer, and C. Prasad Naipaul, father of Nobel Prize winner V.S. Naipaul. Their meetings at Whitehall produced a collection of writings called Papabois, one of the earliest publications in Trinidad. During his 30s, he was also a prolific poet, short story writer, and columnist. At age 33, perhaps inheriting his father's poetic genes, C.A. Thomasos published a book of poetry entitled Poems, and years later, in 1980, he published another called One Moment. As a teacher, he guided his students with a firm yet gentle hand. Yet, as a true son of the Arima soil, he gladly worked as a philanthropist, giving back to his community, were it either building a home for aged women in Arima or as a volunteer for many years with the St. Vincent de Paul Society, or a lieutenant in the Special Police Service during World War II. It came naturally, therefore, when the time to serve his community on a national level presented itself, that he joined the movement for independence, entering party politics under Dr. Eric Williams and the People's National Movement. Thomasos left the teaching profession on October 3rd, 1956, and contested the St. George East constituency seat in the elections of that year. He was elected with an overwhelming majority, becoming a Member of Parliament and the Deputy Speaker for the first 5 years in office. The general elections in 1961 saw him fulfill a promise made by Dr. Eric Williams for Arima to get the distinction of the first elected Speaker of Trinidad and Tobago when he again won his parliamentary seat. On December 29, 1964, he was elected as Speaker and thus began his legendary 20-year tenure as Speaker of the House of Representatives for Trinidad and Tobago. By extension, he became the most senior Speaker in the entire Commonwealth region, as the longest-serving Speaker in that capacity until November 27, 1981. He also became, in essence, the father of the Parliament in light of his stern disposition and his insistence on maintaining British Westminster-style conventions. Former Member of Parliament and Speaker of the House of Representatives, Nizam Mohammed, remembered Arnold Thomasos in this way.
I discovered that he was a man who had a deep interest in literature, and more particularly poetry. And as a result of that, he had given me copies of his published works and so on. And there were times when I surprised him by quoting lines from his poems during the course of debates. And he would be so delighted that I would put a few lines of his poems into the records of Hansard. And I thought that I had won him over in the sense that I discussed his works with him, and I discussed writing and creative writing with him and so on. And I discovered that it was an area for which he had a very, very, very deep passion.
He became involved in the Commonwealth Parliamentary Association and was therefore able to share his vast knowledge of parliamentary procedures and his experience with Trinidad and Tobago's Caribbean neighbors. He also held firm to his belief in upholding the democratic way of life, so much so that even though he retained membership within the People's National Movement, he never participated actively in politics again since the time of the 1961 elections. He felt that his position as Speaker required this high level of impartiality. Outside of the chamber, he was an inspiration to those speakers who came after him, and a mentor to many of them as well.
Arnold Thomasos as Speaker, to start with, he was a rather overpowering kind of individual in the chair. And he had brought into the Parliament, from my own feelings, he had brought into the Parliament this schoolmasterly approach. And from the very outset, as we entered the Parliament in 1976, he established from the very outset who was the individual in charge of the chamber. And he did this in a very, very effective way, so that his utterances and his rulings left no room for argument, no room for talkback, and he made his authority felt by each and every one. He was able to maintain order in the Parliament, and he was very conversant with the standing orders, which rarely organize, or rather dictate, the debates in the Parliament. It allows for, the standing orders allow for the control by the Speaker. And he was very conversant with these rules, and as a result of that, he was able to control the Parliament in a very effective way.
It is fair to say that Mr. Thomasos presided over the House during its golden era. That's when we had great debaters. It's not to say that we don't have great debaters today, But I think people, when they reminisce and think about the House of Representatives, they tend to look back during that era when Mr. Tomassos was, in fact, Speaker. What I can say of Mr. Tomassos is that perhaps he had influenced a lot of parliamentarians. I was in the 5th Parliament when Speaker McLean was the Speaker. Now, assuming that Speaker McLean would have learned quite a great deal from Mr. Tomassos, I then would have benefited from his what he had learned from Mr. Tomassos, because I myself had learned a great deal from Speaker McLean. I think the greatest tribute one can pay to Speaker Tomassos would be if anyone, certainly in my case, were to tell me that I possess some modicum of the charm and wit and competence of Speaker Tomassos.
After years of service, his efforts were recognized and celebrated with his crowning achievement for public service work in 1976, when he was awarded Trinidad and Tobago's highest national award, the Trinity Cross. 5 years later, in 1981, Tomassos survived a heart attack, but was advised by his doctors to retire as Speaker. Then, sadly, on December 20th, 1990, whilst in retirement, Tomassos passed away. Death is not being dead. Cold, the spirit fled. To some uncharted shore, not the vanished touch, the heart knew so missed, so much, still, and no more. Whatever is of dust, forgotten, lost, let it be said of unremembered clay, 1,000 years a day, 'tis to be dead. Although gone, he will forever be remembered and revered as educator, speaker, poet, philosopher, writer, and public servant par excellence.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.
The Red House, situated in the heart of Port of Spain, has a legacy as the home of democracy in Trinidad and Tobago and contains within its walls a remarkable history. The historical significance of the building was further enhanced when, during recent restorative works, there was a discovery of archaeological relics and even evidence of indigenous burials. In order to preserve this history, careful consideration was given to the renovation of the building, which led to the Restoration Committee employing the services of an American architectural company to carry out specific restoration and preservative functions on the building.
Evergreen is a specialty contractor based in New York City in the United States, and we specialize in the restoration and conservation of decorative arts in buildings. So we work on ornamental plaster, decorative painting, works of art such as murals on canvas and on walls. We've worked in Port of Spain at Queen's Royal College, and recently in the United States we've worked at the U.S. Capitol and the United Nations building. What's interesting to me is that the red plaster that's at Queen's Royal College is here at Red House, and it gave this building its distinctive red color before it was painted over. Our objective is to determine historic colors used in the interior of the building, and that would include paint on plaster and possibly wood, or we found that a lot of the wood surfaces were originally stained or clear-coated, so you were meant to see the grain of the wood. And we're also tasked with understanding the exterior color scheme, basically anything having to do with the original color of the building as it was articulated after 1903. So for the finishes analysis and determining the historic colors, we use two main techniques. One is collecting paint samples from the walls and ceiling and other features, and we'll examine those to determine the different color schemes over time. And we also conduct what we call exposure windows in place. And an exposure window is when we remove layers of paint a bit at a time so we can see on the wall what different colors and finishes were placed. Another goal of this project is to preserve the plaster molds that were created previously by Evergreen. In the south chamber, the ceiling was dismantled and the ornamental plaster pieces were cast, meaning we made replica molds, I should say, for those pieces so that in the future we can cast replicas of pieces that have been damaged and then place them back in the south chamber exactly as they were originally. I think the most interesting thing about the red house to me is the exterior red plaster. The red color you see today is achieved through multiple layers of paint, which has a tendency to fade over time as any paint will. But the red color that this building has was originally imparted by a very deep red plaster. Has very beautiful material. The next step for me is I examine the paint samples under the microscope and I cut them in cross section, and that way I can see the paint layers one over the other, so I can determine what colors were used over time in the red house.
The Red House Restoration Project has uncovered many findings, and the team at Evergreen's own meticulous investigation will add to the details that will help in restoring the Red House to its former majesty.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.
Madam President, we met and the decision is that we'll continue the committee of the whole.
Sure. So, Honourable Senators, when we left off, we were dealing with page 3 of the bill and with some proposed amendments to clause 2C, which had been proposed by Senator Choate. I think we have spoken about C and then C1. Could we move on then to
Madam Chair, on C1, just to
Yes.
conclude the discussion, because I had a chance to speak with Senator Choate in the break. We are prepared now, having a little bit more reflection and some time to discuss, to actually insert the words "or cause a charge to be laid" as proposed by Senator Choate. So that would be in the first line at Roman 1.
All right, but what about
No.
by any person, C itself?
Yes, no, Madam Chair, for the reasons offered.
Right.
But with respect to C Roman 1, after the word charge appearing in the first line, insert the words "or cause a charge to be laid."
Okay. All right. So let us move on to D, which is now Senator Choate has proposed as follows. To D, the misrepresentation of a material fact by the prosecutor, and to insert these words now, or anyone acting on his behalf, or anyone involved in the investigation of a matter. Of a matter or the matter, Senator Choate?
The matter.
Attorney General.
Madam Chair, we consider this position because we've specifically defined the prosecutor as the person who is acting in the matter, specifically, that we were looking to that improper inducement as it found itself in a plea agreement. And because we're looking at it in terms of a narrow scope, that prosecutor, we've preferred to leave it as it is. So, first, before I conclude though, if I could just understand, in D, the proposal is the misrepresentation of a material fact by the prosecutor or anyone acting on his behalf or anyone involved in the investigation
Of the matter.
either before a plea discussion is entered into or during the course of the discussion.
Yes.
Just hold one moment. So, yes, please.
Yeah, AG. Based on the basis upon which we rejected the proposed amendment to C, before we get to C1, the first one, which was by any person, the basis upon which you didn't accept that was that we wanted to stretch it as wide as possible to capture as much people as possible by it. So if we use that reasoning in relation to the proposal by Senator Choate, why do we want to narrow it to only a prosecutor when you may have other persons who may not fall within the definition of prosecutor, which is exactly the reason why we had rejected by any person in C. Why do we not want to allow the net to be cast as wide as possible by anyone acting on his behalf is what I have. What the proposed amendment by Senator Choate will achieve what you wanted to achieve at C first.
Okay. The original reflection on the inclusion of by any person in the chapeau to subparagraph C was that from our view, the definition was wider as opposed to including it. The prescription that we're putting now when we're talking about the focus point of prosecutor, when we're dealing in D with the issue of the prosecutor is the person who is authorized by the DPP to enter into this plea discussion and therefore plea agreement as it's presented to the court. That prosecutor has to stand by the matters in the plea discussion, now plea agreement. And when we look to section 25, clause 25 of the bill, we've actually included a fairly broad power that the court may reject a plea agreement entered into between the prosecutor and the accused person if the court considers that it is in the interest of justice to do so. So we have a very wide position which is a general overarching discretion of the court even outside of the parameters of an improper inducement, which is just one of the reasons that you can actually set aside a plea agreement or have a court not agree upon it. So because of the breadth of Section 25, Clause 25(1) of the bill, we felt that there was no need to necessarily be completely prescriptive in the general description of an improper inducement, as we've set it out in Clause 2.
Honourable Attorney General, if I may. Madam Chairman, I beg your pardon. What I'm trying to suggest by this proposal is that we put some depth to the section. You have already made it clear that as a matter of policy, there will be no criminalization of impropriety. Now, how does it, I ask myself, how does it serve the interests of justice to allow one segment of the process which may result in a plea bargaining agreement to be sullied and only be found out when the person goes before a court? Why should we not consider having a depth of legislation so that it constrains people from seeking to abuse the powers granted under the legislation in the first place? It is of no comfort to me to say that you can always make a complaint afterwards. There's no guarantee that your complaint is going to be accepted or taken on board. But the point is, when you give great power to persons in circumstances like these, which will determine the liberty of the citizen of this country, I think that we owe it to these citizens to ensure that the legislation that we create has depth, and that we cover all reasonable prospects of abuse that we can see, and the legislation is worded in such a way to avoid or prevent that abuse.
Okay. May I respond, Madam Chair?
Yes.
It isn't that we say, and I want to be clear about this, that there is no criminality for an improper inducement, because the common law still applies. Misbehavior in public office, perverting the course of justice, breaches under the JLSC rules, for which there are matters that can be prosecuted against the officers who are members of the JLSC, all of them at the DPP's office falling under that rubric. So that section of the law still exists. What we've come into in not criminalizing the improper inducement position is the significant voices that have brought us to the position where it was advanced that you should not expressly criminalize improper inducement. So that's just on point one. On point two, to create the depth, well, we are allowing an improper inducement to be very broadly categorized. Secondly, it includes all threats, so it doesn't have to be an act, it could be a threat of something which had not yet materialized. But thirdly, isn't it true to say that any remedy for an improper inducement is always in arrears? Because it's only when you come to the point of having been duped, so to say, that you make the complaint. So prescribing that there is depth to say, let's take care of all opportunities, is always found out in arrears. You always complain about it after the fact and then seek a relief. So you will always be in that situation where you say, well, what I thought was going to be the case or what was operating in my mind shouldn't have happened, and I want this thing not to prevail. And worse yet, I want somebody to be penalized for it or to be held accountable for it. So I think that we are in fact achieving or leaving room for that to be achieved by operation of the common law, and by the fact that when we get to clause 25 of the bill, that it is the court that has the widest discretion in 25(1).
Honourable Madam Chairman, just finally, I don't, with all due respect, once again think that the Honourable Attorney General has really addressed the concerns which I have. What I am trying to put across as plainly as I possibly can is that in the definition of an improper inducement, you want to say that a prosecutor, as you describe him later on in the definition, or any person acting on his behalf, because the prosecutor may be an attorney at law authorized by the DPP. If that attorney at law authorizes someone to make a misrepresentation of fact to the suspect or the accused, then that person will be caught. But if the improper inducement, if we don't add this in, then all that the accused person could go and say is, well, so-and-so misrepresented something to me. Well, there's nothing here which says that he was protected from that in the first place. Is he now going to bring a private complaint after he's entered a guilty plea to institute proceedings against this nameless third party?
But that belies the fact that the prosecutor owns the plea agreement, because it's the prosecutor who's authorized, the prosecutor who conducts the plea discussion, the prosecutor who takes the plea discussion to the plea agreement, the prosecutor who appears before the court and makes the representations before the court that these are the material facts. There were no threats, there was no coercion, there was no improper inducement. It is for the prosecutor to own that responsibility. So to say that the person is without remedy, the prosecutor has got to be the person who owns the material.
Senator Sturge wants to make an intervention. Senator Sturge?
Yes, I have 3 points, Madam President. The first thing would deal with the issues being raised by Senator Trout, quite rightly, because the legislation as it stands to close, it is specific to the prosecutor. And if one understands how interrogation goes and so on, the material misrepresentation may come before the prosecutor enters the picture. So that if you want to capture both the prosecutor or anyone else in terms of what is proper drafting, I think the better thing to do would be to strike out the words by the prosecutor in D. So if you have the misrepresentation of a material fact, either before a plea discussion is entered into or during the course of the discussion, then it doesn't limit you to the prosecutor. It can extend to persons acting or purporting to act on his behalf and so on. So you get the widest possible interpretation and you'll catch the widest possible mischiefs instead of enumerating all of the persons who can be caught by deleting the words by the prosecutor.
Well, Senator Trout's suggestion is not to delete, it's to include, to insert words after.
I appreciate that, and that's what I'm dealing with.
Right.
What I'm saying, I understand Senior Senator Trout is in essence dealing with the widest number of persons who can be captured, and I understand the rationale for it. But what I'm saying is instead of enumerating, we can achieve all of that by simply deleting the words by the prosecutor. That's the first thing. The second thing is...
So you are proposing an amendment on an amendment kind of thing?
No.
You see, I'm just trying to... You are proposing that further words be taken off from the clause, correct?
Yes. My lady, sorry.
Yeah. It's okay.
Madam President, I just wish to respond to certain issues raised by the Honorable Attorney General. The Honorable Attorney General made mention of the need not to criminalize, and he has stated in essence that there will still be sanctions in criminal law by the charges of misbehavior in public office and conspiracy to pervert the course of justice. If these two common law charges are available and therefore the prosecutor is criminalized in any event, then why not make it specifically criminalized in statute? Because if you are saying the prosecutor entering into an improper inducement can still be charged under the common law charges of misbehavior or conspiracy to pervert the course of justice, then why not include in the statute, since common law already exists, the charge, the criminal sanction which exists already in the existing law? And secondly, or lastly on that issue, if you are specifically decriminalizing the behavior of the prosecutor by this statute, then one may wonder what one is doing with respect to the common law charges of misbehavior and conspiracy. One may say that by implication it doesn't arise, and with the rules of the canons of interpretation, one may say, well, this deals specifically with improper inducement. So if you are dealing with an improper inducement, although it's common law misbehavior or common law conspiracy to pervert, the very fact that they've left it out, it means that these two offenses, that the behavior of improper inducement therefore cannot apply to the common law misbehavior or conspiracy to pervert, by implication.
Madam Chair, I thank Senator Sturge for his contribution there. Good fulminations. We are expressly removing, by way of repeal, Section 5 of the existing law, which provided an express criminal sanction for an improper inducement. We are specifically not bringing on to this, by removal of Section 5, a reading down of the common law. If we had amended the statute, there is always the implied repeal that can happen, or the reading down of other statutes by a subsequent amendment. So a statute which steps forward and amends X in this way, which didn't expressly treat with earlier laws, because it had failed to, for some reason or other, may be read down by that. But that's applicable in terms of interpretation to statutes. The common law itself, as I understand it, is not to be read down by the repeal of a particular offense in a statute. In fact, this aid of the common law still stands. And you did ask a very, very good question. Well, why, if it's there in common law, not do it? Because if there's a criminal sanction, why not just bring the elephant into the farm as opposed to having it in the room? Well, the fact is that there is still a process to get to the common law offenses, and that in and of itself was good enough for those many contributors to have said, look, one of the dissuasive aspects of the criminalization in Section 5 was its express criminality. So there is a hurdling, and therefore there's a rationale, because it's now one stage removed. But if I go to Senator Choate's position, a prosecutor is defined as somebody who is expressly authorized by the DPP to enter, and that includes, yes, an attorney at law who may be authorized by him. So therefore the words, or anyone acting on his behalf, there can be no implied agency in respect of how that prosecutor manages. It must be express agency. So those words don't take us into an improvement when I think about it, because the inclusion or anyone acting on his behalf would take us away from the express provisions that we provided, where the prosecutor must be the prosecutor authorized expressly in writing by the DPP and no one else. Anyone else who would have acted that way is not allowed under agency because he doesn't have express approval. So that would be ultra vires, if I could borrow the expression there. The question is in relation to an inclusion of or anyone involved in the investigation. So that's stepping behind the prosecutor's ownership of the position and going now into the investigative aspects. But what we seek to do in terms of a certainty of this law is to hold the prosecutor responsible for these matters. Because if you flip it on its, if you turn it on its head, and I include or anyone involved in the investigation, then any mere allegation takes us forward. But when you jump to clause 30 of the bill, and you look to the manner in which you may have grounds for withdrawal from plea agreement and an appeal by an accused person, the court may, upon application by an accused person, allow the accused person to withdraw from a plea agreement at any time before sentence, or to appeal against a conviction or sentence based on the plea agreement if it was entered into as a result of an improper inducement. Stick a pin. That's where Senator Choate's argument comes alive. Well, let's deepen the definition of improper inducement. B, it was entered into as a result of a misrepresentation as to the substance or consequence of the plea agreement. or C, the prosecutor has breached the terms of the plea agreement. So the question is in 30A, tied back into improper inducement, whether we want now to include or anyone involved in the investigation. So that is the misrepresentation of a material fact by the prosecutor or anyone involved in the investigation. And our position is that we want to hold this on to the prosecutor who, if he accepts something that he should not have accepted, would in fact not have a defense against those common law offenses which may meet him for perverting the course of justice or misbehavior in public office, where he turns around and says, well, hold on, it was John Brown who really did that and not me, and the law recognized that John Brown may be culpable. So from our perspective, we don't propose to move any blame away from the prosecutor. It would be to open the door a little bit too wide to defenses available to the prosecutor when called to answer for allegations for breach of the common law.
Madam Chairman, if I may, sorry.
Yeah, I wanted to make on this particular point, and I simply wanted to inquire of the AG, and it's building on the point of Senator Sturge and Senator Choate, whether he is envisaging a situation where the prosecutor will not under any circumstance have anyone acting on his behalf with improper inducements. So are you saying it is not going to be possible at all, AG, that the prosecutor who takes ownership is not going to have this particular individual who is going to offer the improper inducements? And if it is, you can give me the assurance that it is not in the realm of possibility, then I say, well, okay, the words anyone acting in his behalf become superfluous. But if it is at all possible that the prosecutor can have an individual who is offering these improper inducements, then I see absolutely no harm but in the public interest for including anyone acting in his interest.
Clause 6 of the bill expressly states, a prosecutor shall not enter into a plea discussion or conclude a plea agreement unless the prosecutor first obtains the written permission of the Director of Public Prosecutions. And a prosecutor is defined in Clause 2 as, and that's on page 4, the Director of Public Prosecutions or an attorney at law authorized in writing by the Director of Public Prosecutions to engage in a plea discussion or conclude a plea agreement. There's a very square responsibility on that prosecutor. There can be no delegation of that authority to your clerk, to your servant, to anybody else. You are the attorney at law on record on this matter, and you take the responsibility and liability for plea discussions, for the material advanced into a plea discussion, taken to the court in a plea agreement, put before the court, and you have that point. And that is why I feel a sense of comfort that the common law remedies or common law offenses of misbehavior in public office, perverting the course of justice, coupled with the JLSC's ability in respect of discipline of its officers, if it's DPP officers, or another form of disciplinary measure, for instance, under the Legal Profession Act, where you can be disbarred for certain circumstances, either for breach of Part A or Part B of the 5th schedule of that particular act, allows for a suite of remedies to pinpoint the person. So specifically because there can be no escape around prosecutor and it's tightly managed is why I don't think respectfully that we need to broaden it into a conversation about agency.
Honorable Attorney General, Madam Chairman, I beg your pardon, with all due respect, even the language which is being used by your good self to defend the position that the subsection remains unamended doesn't sit well with the intent and purpose of the law, and references to other sections within the bill to answer or to address the difficulty contained in this subsection doesn't advance us anywhere. The fact of the matter is, you have not been able to squarely address Senator Mahabia's question as to whether it is outside the realm of contemplation that the event which he described may occur. I think anyone with common sense will accept that such a situation may occur. So what I am proposing to do, Madam Chairman, I am withdrawing my proposal of all these other words being added in, and instead I am proposing that the words by the prosecutor be removed, because I think Senator Sturge's approach fits in more neatly with the language of the Act, and it goes with the intent of the Act as you have set it out, which is to say, make it as wide as possible. So if Madam Chairman, you would permit me, I will withdraw my initial proposal for the amendment and ask that this be substituted.
So, yeah.
Madam Chair, I'm just considering the proposal.
And in the meantime, I will just put it what it is so that all members will just take note. So that clause D, to subclause D, we are on page 3, will be the misrepresentation of a material fact, and you're deleting the words by the prosecutor. Okay? That's what you're proposing?
Yes, Madam Chairman, thank you very much.
Madam Chair? We'd be very pleased to delete the words by the prosecutor.
Obliged, thank you.
Senator.
Sorry. I just wanted to make an inquiry, Madam Chairman, because I had been going through my proposals and we sort of got stuck when we got to C and D. I don't know if I had finished my...
No, what I'm trying to do is to go page by page.
I see.
So we're still on clause 2.
Yes.
And we're dealing with page 3.
Thank you very much.
Still dealing with clause 2. We still have another proposed amendment from you, which is in respect of clause E, subclause E. Senator Mark, you wanted to say something on clause D? Yes.
Madam Chair, it is not beyond the realm of possibility for anyone, whether prosecutor or somebody acting on behalf of a prosecutor, or anyone acting on, as I said, on behalf of the person. I would like to ask the Attorney General, what was the reason submitted by the team in 2014 that decided to remove the word fraudulent in D? Madam, we are doing the current legislation.
Yes.
And we are amending. This is
okay.
So, in other words,
so you're looking at the existing law.
Yeah, because
I see. Because I understand. I can answer.
Because what I'm saying is that we are in the real world.
Sure.
And there is always a possibility.
Through you, Madam Chair.
And that's what I'm...
The fraudulent brings a higher burden rather than bare misrepresentation. So we're actually allowing for a wider, how should I say, turpitude on the part of the prosecutor. So misrepresentation is an easier, larger basket rather than qualifying it with fraudulent. And that's the answer.
Can I ask, what would be the point in just using a term that is not necessarily criminal in a statute dealing with criminal law?
Because this is vitiation of an agreement. The consequences of vitiation of an agreement at law doesn't need to be necessarily a criminal matter. They are misrepresentation, there is a mistake of fact, and they are qualified usually by the usual equities of delay and acquiescence, etc. So we were looking at it more from a contractual perspective rather than a criminal perspective.
Good.
So we move on now, members, to subclause E. Senator Choate's proposed amendment is as follows. an offer or promise, the fulfillment of which is not, and you're including the words, capable of being fulfilled by the Director of Public Prosecutions.
Well, the office.
She didn't say it.
May I?
By the, yes, you took it off. Or? Senator Cho, did you keep the words office of the director, or you took those words off as well?
It would have to be removal of the words office of as well, because the prosecutor would be the Director of Public Prosecutions or the Attorney at Law acting authorized by him.
So that the proposal, I will read it again, an offer or promise, the fulfillment of which is capable, is not capable of being fulfilled by the Director of Public Prosecutions. Yes?
That is so,
Senator
Madam
Choate?
Chairman.
Is there anything you wish to say on the proposed amendment? Senator Choate?
Again, it is to keep with what seems to be the intent and policy of the government in proposing this legislation, which is to say to make it as wide as possible and to capture as many fact situations that we can. So an offer may be made to a person which the director is not capable of fulfilling, for example, a plane ticket to another country, and so on. And this would cover that.
Madam Chair, just to try and, I understand and thank Senator Choate for the observation. We went back to Section 83 of the Interpretation Act and looked to the definition of function. When we looked at the definition of function, function speaks to jurisdiction, power, and duty, which is why we had elected to use the word function. Your jurisdiction speaks to the fact that you have the locus to actually offer the thing which you have. Your power is the ability to carry it out or to make it actually happen, making it, the capability come into effect, and then your duty, whether you had a duty to do it. So the drafters directed me to Section 83 and to the specific interpretation of the word function, because function was intended to speak to those multiple aspects. So I wonder if Senator Choate's view is qualified at all by that response, function therefore actually treating with capability in and of itself.
To some extent, but I still see that we need to remove the words of the Office of the Director of Public Prosecutions, because, as you say, if you want to hold the prosecutor liable, you want him to own it, as people say nowadays, then a reference to the function of the Office of the Director really is.
Yep, Senator Choate, I agree with you.
Okay.
So the words, so the proposed amendment, Senator Choate, is as follows: an offer or promise, the fulfillment of which is not the function of the Director of Public Prosecutions. So we are taking off the words, the office of the office of, correct?
Yes.
We're deleting those words.
Yes, Madam Chairman.
So Senator Choate, we turn to page 4.
I understand the rationale, but I was wondering if we could, I have a few amendments in addition to improper inducement. I was wondering if we don't want to complete that before we go into the rest of the other parts of the definition section.
But we dealt with your amendments that you had.
Not in the notice, outside of the notice that I wanted to suggest to the AG. Yeah.
On page, just a second, on page 3?
On page 3, yeah. Yeah, AG, I wanted to suggest that in A, that we take off not believed to be supported by provable facts and simply put what is the position in relation to the malicious prosecution test, which is what has to be satisfied in any event. That is the laying of a charge without reasonable cause. I think that would make more sense having regard to the law, because basically that is, as you answered to Senator Mahabe, I think that covers the duty that a police officer has to discharge in relation to this. So I was suggesting that. But I also want to suggest in relation, even before we get to without reasonable cause, that we adopt what we've done in relation to C1, which is the laying of a charge or causing a charge to be laid without reasonable cause. So that captures and brings us in sync with what you've done in relation to the suggestion by Senator Choate about C1. So I think that will strengthen us there.
I think that that's a good proposal. I'd be happy to accept it. So it would read, the laying of a charge or
causing a charge to be laid
without reasonable cause. Yes, I heard you. And we'd have to make an adjustment to B as well, of the causing of a charge.
Well, I don't understand what is the mischief, because I don't understand what is being caught by B. The laying of a charge that is not usually laid with respect to an act or omission of the type attributed to the accused person or suspect. And the difficulty I have is that I don't know what is the mischief that, I don't know if it's the drafting, but I don't know what it is that we're trying to capture by that.
Because it may be, in the improved language of A, it may be that B is in fact
I was going to suggest that we take out B.
Yeah. Just a moment.
Yeah, sure. Reasonable goal. Might be, yeah.
What about the evidence that is obtained as a result of the
Senator Romney, we'd be prepared to agree to the deletion of B. Madam Chair, may I, through you, bounce that off of Senator Choate as well?
Agreed.
Thank you.
And
Madam Chair, A would read, the laying of a charge or causing a charge to be laid without reasonable cause, full stop. Thanks.
Members, may I turn the page to page 4?
My lady, I just had one observation. Madam President, under F, and I'm borrowing on, have one before F? All right, good.
in relation to C, we have, you had not agreed with the amendment that was proposed, but I want to ask whether you would not want to consider that in C, you have the coercion of an accused person or suspect to enter into a plea discussion, including a threat. Why have we limited it only to the plea discussion and not and a plea agreement? Because you can have, I can envisage a situation where an accused person could be forced to enter into a plea agreement without having any plea discussion at all.
Well, you have to have a plea discussion to have an agreement.
Not if you're doing it unlawfully. Suppose, let's take an example. Suppose a prosecutor comes and says to an accused person, if you sign this, this is the position, without any discussion.
That's still a discussion, because the agreement is only an agreement. Hold on, let's look at clause 25 for a moment to consider what you're saying, before I answer too quickly. Sorry, before 25. I see what you mean.
I think on a purposive instruction, AG, I understand I understand, perhaps it might not be the best example, but I'm saying, there can be a situation where someone can sign a plea agreement and there be purposively no discussion.
Senator Ramlin, you're right. I've just jumped to part 4, clause 19. And what happens is, we have a discussion, and then we describe a plea agreement concluded. So, we actually do have the position. I just want to check the schedules. Yeah, so that would be Form 7. I think you're right.
So we can add it, or plea agreement, right after the word discussion.
Yes.
And I just wanted to ask you, AG, whether you would not...
Just
Sorry.
1 second, Senator Ramley.
Sorry.
So we're now moving to C, the coercion of an accused person or suspect to enter into a plea discussion
Or plea agreement, and then it continues.
including a threat. Right?
Or conclude a plea agreement. So to enter into a plea discussion, or it should be, or conclude a plea agreement.
Where is C?
C. C.
Sir, do you wish to say anything, or can I move on?
No, I'm...
I had an observation under F, so I was...
AG, but I'm not finished with C. I was wondering, AG... sorry.
Senator Ramdi,
Sorry.
can you address me, please?
Oh, I'm sorry, Madam
Yes.
Chair. I apologize.
Yeah.
Madam Chair, through you. AG, I'm sorry, Madam Chair. In relation to C, after we make that amendment, you then define, you narrow the compass by saying including a threat, and then we limit it further by defining in 2 circumstances. I was wondering, AG, whether the mischief that we are trying to achieve is not to capture any threat, and the fact that we've now narrowed the threat to A and B may leave out. I can't direct my mind now to conceive what may be the any other threat that is not covered by 1 or 2 will not be captured by the section.
it's got some good news. Yeah, sorry, Senator Ramney. So yes, we would first of all need to delete the reference to or B in Roman 1 of C in light of the deletion of clause B, subsection B. But you're now coming to
I'm actually not, I haven't worked out.
No, I understand. You're coming with what is the provision for a catch-all for any other threat that we may not have contemplated?
As it is here.
I understand.
So your drafters may want to consider whether we put
Madam
something.
Chair, if you could just give us a moment to think of that. Yes?
And in the meantime, I would just ask Senator Cho, your initial proposed amendment C, are you, because at the end, I'm going to have to put all the amendments that have been proposed. Are you withdrawing that amendment? Because Senator Ramdeen has now made a proposal that the Attorney General has said he will accept, subject to the agreement.
Just to be clear, is that the proposal of the insertion of the words by any person?
Yes.
If I am prepared to withdraw that?
Yes.
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 So now we have the creation of any unaccused.
Cousin. Yeah. Sorry, Madam Chair, may I through you inquire whether, if we think about clause C as drafted and as amended, we note that the language is really the coercion of an accused person or suspect to enter into a plea discussion or conclude a plea agreement, including a threat. So it wasn't intended to be an exhaustive list. And I've just double-checked to see whether we are read down by the ejusdem generis rule, and we're not. As I understand the ejusdem generis rule, it is in a different formulation of words that applies, where we've specifically circumscribed the type of examples. But it was intended, and as explained to me by the CPC's department, that including really was for all other circumstances. And as explained to me, the ejusdem generis is that you have a specific circumstance and then you give general words about it, whereas this is the converse.
No, but you see, AJ, the problem with that reasoning is that what we are circumscribing is the coercion. The ejusdem generis would come if you are dealing simply with the specific, the particularities of Roman 1 and 2.
Madam Chairman, I'm wondering if I could just perhaps suggest that a simple punctuation mark might assist us with the reading of the wording of the subsection. So if we put a comma after discussion, it would make it clear that there is, it's wrong to coerce an accused person or suspect to enter into a plea discussion or to conclude a plea agreement. I'm not sure if I used the words in the right place.
Yeah, you did.
And then including, and the coercion would include a threat to do these two things which are set out, but it would not necessarily exclude other forms of coercion.
I think that would be very helpful. Thank you. If I may just on a lighter note that when Senator Prescott sat in that very chair, it was very often his use of semicolons and colons that saved us from a lot of difficulty. So I thank you, Senator Chu, through you, Madam Chair.
Okay, so could I just ask where that comma
Yes, ma'am. It'll go after the word agreement that we've just inserted. So the clause would read, the coercion of an accused person or suspect to enter into a plea discussion or conclude a plea agreement, comma. We continue the words in Roman 1, we delete.
Yeah.
Or,
that's fine. We have all of that. Yes. All right. So we move down now to F. Senator Sturge, you wanted to suggest an amendment?
I wanted some guidance on why the word continued was used at the last line of F. Particularly keeping in mind the case law, because if this section only bites if there's a repeated or continued denial of guilt, then it in essence permits, in the face of someone saying...
We can delete it.
You can?
Yes.
Lovely. Thank you.
The word continued.
Okay. Madam Chair, can I come in here on the same clause, subclause?
Sure.
Yeah. You see, Honorable Attorney General, it starts with one attempt to persuade the accused person to plead guilty, notwithstanding the accused person's or suspect continued denial of guilt. And I'm just wondering where an accused person has been saying day after day after day. I'm saying attempts.
I'm told that legislatively the singular includes the plural.
All right. So an attempt means many attempts.
Well, actually what happens is that each attempt stands on its own. So that's why when somebody commits a certain larceny, that you have multiple counts that may happen.
If I could, Madam Chairman, just add so that it would be clear as well, an attempt may also involve a course of conduct. So it's covered.
Thank you, Senator Cho. Through you, Madam Chair.
Page 4. And as we turn to page 4, could we do, if anyone has an amendment, a proposed amendment, could we do it chronologically, please? Yes? Chronological, I want to, same thing. Yes. Any proposals on page 4 for amendments?
Can I come in here, Madam President? On page 4, plea discussion, under plea discussion AG, plea discussion means a discussion held between a prosecutor and an accused person or a suspect for the purpose of arriving at a plea agreement. I would have thought that you would add, and an accused person or a suspect or his legal representative.
Because we've allowed for it's the suspect who has to be there, whether he has counsel or not, it's still him. So we're dealing with the person who is the victim of it, because he's the person who has to actually physically enter into the agreement. Whether represented or not, he still signs, and the forms reflect that.
Okay. And if he cannot sign, if he cannot read, if he is unable...
There's an interpreter's clause, and then there are rules and judges' rules that apply when someone is incapable of signing, has no hands, can't write, all of those circumstances, deaf, mute.
Yes, thank you, Madam Chairman. My proposal is with respect to the last item on the list. I am proposing that the word relative be removed, and that we simply say appropriate person. That we remove relative and we say appropriate person. And then instead of restricting the appropriate person to family relationships, we would allow someone who doesn't have any family here, as sometimes happens, to be considered. When I had made my presentation, I had made it in the context of it would exclude any inappropriate person.
I catch you. Through you, Madam Chair. The difficulty we had, actually this amendment to the definition of relative came from the Leader of the Opposition. And we looked at it, and there was a concern that it was too narrow, and in particular Romans 6, which appears on page 5, came up for consideration. Any other person who the court determines to be of sufficient proximate relationship, whether by blood or otherwise, to be considered a member of the victim's immediate family. So I accept that Romans 6 seems to be working our way out of a definition of a relative. The literature which we looked at coming out of Canada, Australia, and other jurisdictions which and the DPP's rules in England, which gave us this concept of a victim impact statement being tied to a relative, quote unquote, really drove this definition. So it was intended to tie into Part 3 of the bill. I understand the reflection to be that we may be excluding someone who the court may otherwise be prepared to have come to the court. And really, I think, whilst it may be inelegant, that Roman 6 of relative definition Part A really deals with it, because the attempt was really not to allow just anybody to come in, I don't mean to use this term badly, but any busybody or person who rolls up to the court and says, I have an interest to come in, but really to try and put circumstances around the nexus of the persons who are most affected, as opposed to persons who may come in for a public interest perspective and say, well, look, I have a genuine right. I'm the promoter of Arrive Alive. No offense to that excellent lady who is. And therefore, I want to deal with this person's conviction for recklessness or causing death by dangerous driving. So I think it was that we were really intended to drive by putting this relative definition in. I don't know if I persuaded you that, as inelegant as it is, that A, Roman 6 may take care of the concern?
Well, not entirely, but I was wondering if we could not say then any appropriate person who the court determines, instead of saying any other person.
Sure. I wondered whether, through you, Madam Chair, we would not be tripping on what appropriate means.
Well, certainly it would mean something. You have left it wide open here. Any other person. Any other person could be friend.
So would we, through you, Madam Chair, be inserting after the word other appropriate? So just...
Other than put in appropriate.
So as opposed to any other person, any appropriate person who? Sure?
Yeah. Page 5. No, 5. Page 5. And 6 at the top.
The definition of relative. Madam Chair.
Senator Choate, any further proposals for amendment?
With respect to
with respect to page 4. Into
with
5.
respect to page 4, no, my lady, Madam Chairman.
Yeah. All right. On page 5, any proposed amendments? Then, Honourable.
My lady, I beg your pardon. I don't have a proposed amendment, but I have a question with respect to the exclusion of exclusion of the state as a virtual complainant.
We looked at that. I thought that was a very interesting reflection. I went back and I considered, for instance, the claim against the Jamaat al-Muslimin, where the state suffered damages and, wanted to come up. But then what struck me, through you, Madam Chair, what struck me was the inequality of arms, insofar as the state has alternate remedies as it comes to damages, because the only circumstance that I thought that the state could really involve itself in with that inequality of arms was the pursuit of damages, that it would be rather unequal in the race to allow the state to come in and deal beyond a prosecutorial function with a victim impact event. So from that perspective, I thought that we should perhaps keep the limit where it was. I thought it was a very novel suggestion, however, it did cause me some concern as to what a response could be.
So, Honourable Senators, I think I now have to go through each amendment put it to the committee, and then I will put the entire clause as amended to the committee. And this is clause 2. So I ask you to bear with me because there are several amendments. So the question is that clause 2 be amended as proposed by Senator Ramdeen. No, I have to.
There was agreement. It has agreement on all the amendments.
Okay. So that clause 2 be amended at page 3 of the bill. Improper inducement includes the laying of a charge or causing a charge to be laid without reasonable cause. So we are deleting the words not believed to be supported by provable facts. All in favor say aye.
Aye.
Any against? The ayes have it, so this particular amendment is accepted. At B, by deleting B. Sub B. All in favor say aye.
Aye.
Any against? The ayes have it. The amendment is approved. At C, the coercion of an accused person or suspect to enter into a plea discussion or conclude a plea agreement. Comma. Those in favor say aye.
Aye.
Any against? The ayes have it. This amendment is accepted. In Roman 1, C1, to lay a charge, and you insert the words, or cause a charge to be laid. Those in favor say aye.
And also delete B or B. Or B, right here.
Oh, I'm sorry. To lay a charge, and you're inserting the words, to cause a charge to be laid, and you're deleting, that's what I said, or cause a charge to be laid, and then you're deleting or B. You're deleting the B. Yeah? Are you taking out the or too?
Yes, or B.
Or B. Okay? Those in favor say aye. Aye. Any against? The ayes have it. Then D, the misrepresentation of a material fact. You're deleting the words by the prosecutor. Those in favor say aye. Aye. Any against? The ayes have it. In E, you're deleting the words of the office.
Yes, that's correct. Yeah, of the office of.
Of the office of.
Yeah. You can't delete the second of. It needs to read with one of.
So you're deleting the words.
The office of.
Yeah. The office of. So it will read, an offer or promise, the fulfillment of which is not the function of the Director of Public Prosecutions. That is how the clause will read. Yes. Those in favor say aye. Aye. Any against? The ayes have it. In F, you're deleting the word continued. Those in favor say aye. Aye. Any against? The ayes have it. The amendment is accepted. And then we go to page 5, Roman 6. You're deleting the word other and replacing it with the word appropriate. All in favor say aye. Aye. Any against? The ayes have it. That amendment is accepted. So, honorable senators, the question is that clause 2, as amended, now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 2, as amended, now stands part of the bill. So, honorable senators, at this stage, I can see the looks that I am getting. We will suspend and we will resume at 10 minutes past 6.